Good morning, everybody. Till the previous video, we have completed up to Article 147 relating to the Supreme Court of India. Prior to that, we have already discussed the role, responsibilities, discretions, and duties of the President of India and his relationship with the Union Council of Ministers. So, today, let us start the topic of the state governments, the appointment of governors, appointment of state ministers, and the relationship between the governor and the state ministers. In some of our previous videos, I informed you that President of India is the executive power of the Union which extends to the matters on which the Parliament is entitled to make law under Article 73. And the governor is the executive power of the state. His powers extend to all matters on which the state legislatures are entitled to make law. The matters relating to the governors and the state council of ministers are contained in Articles 153 to 167. 153 says that there shall be a governor for each state. There shall be a governor. This is sine qua non. It is a must there should be a governor. I explained you in my previous videos that President of India is the only elected executive in India, while there are legislatures in the form of assemblies, state councils, the Lok Sabha and the Rajya Sabha. They constitute legislatures while the executive consists of the president and the governors. The legislative members of the Lok Sabha and the state assemblies are elected by the people, while the president is elected by all the elected members in India in the legislatures, namely the state assemblies and members of both houses of the parliament through a secret ballot without issuing a whip. This makes this country unitary because there is only one elected executive in India, none other. Every authority in India is appointed by the President of India and is also removed by the signature of the President of India. In some cases, he can terminate the services of certain authorities like ministers and governors and attorney generals at his pleasure. Whereas, as regards the constitutional authorities are concerned, like High Court judges, Supreme Court judges, Auditor General of India, Election Commission of India, such constitutional authorities are removed by the signature of the President. But prior to that, it must be passed in both houses of the parliament. So, as regards the constitutional authorities and the judges of the Supreme Court and High Court, the power of appointment is with the President of India, but their removal is not totally in his hands. It has to be approved by the parliament. That is the kind of parliamentary democracy we have. That is how legislatures are respected. Thus, there shall be a governor for each state. The President of India being elected by the electorate consisting of the members of the assemblies and members of both houses of the parliament, he appoints governors under his hand and seal, under warrant. This is contained in Article 55. Article 54 states that the executive power of the state shall be vested in the governor of that state, which he shall exercise either by himself directly or through officers subordinate to him, in accordance with the Constitution. Please understand the language used in Article 154. Governor is the executive power of the state and he shall exercise his office either by himself directly or through officers subordinate to him. This means that the governor of a state, like the President of the Union, has executive powers and they can exercise them either directly by themselves or they may delegate such powers to the ministers who are appointed by them. Unfortunately, we are understanding that the President and governors are secretaries to the Council of Ministers who are appointed by the executive. In India, somebody is becoming chief minister with majority in the assembly and some other is becoming prime minister with majority in the Lok Sabha. Such a system is not contained in Indian Constitution. Such provisions are there in Pakistan Constitution under Article 91, 95 and 130. Election of Chief Minister and Prime Minister in the legislatures is not contained in Indian Constitution. Only the President of India is elected and he appoints union ministers, he appoints governors, and governors appoint the state ministers. And the terms of ministers shall be during the pleasure of the executive, namely the President and the governors. This is the structure prescribed by the Constitution for India, unfortunately, which is not understood by the polity, press, and judiciary of this country. Some people argue there is no need for the post of a governor. He is bound to act according to advice of the Council of Ministers. If the Constitution says that he is the executive power of the Union under Article 154 and further says that he shall act according to the advice of the instructions of the President of India in case of there is ambiguity, who anybody else is to say that his position is redundant, then what happens? Only the legislative leader will rule the state. Then where is the executive? Without there being an executive and without there being separation of powers, how there can be democracy in the country? The resolutions passed by the majority party in the assembly become law. So the word of the chief minister becomes law, and the majority party can make whatever law they require. They may loot the resources of the state. They may appoint all their friends and relatives and financial contributors to different political posts. They may award all contracts, sandwiches, mines to their cronies, and they will resort to retribution on the opposition parties and oppress them. Their financial resources are attacked. False cases are foisted against them. They will be imprisoned. Whoever revolts or questions will be beaten up by the party workers and the constables without any remedy. If we think it is the democracy, it is what contained in the Constitution, there will not be any bad constitution in the world than this. But the truth is that Indian Constitution did not prescribe such a course of action for the governments, formation of the governments and their dissolutions. Indian Constitution is not only the largest written constitution in the world, but also the best constitution in the world. We should admit that, and we must be thankful to great Dr. Ambedkar. However, we should also be thankful to all the constituent members who participated in drafting the constitution and finally approving it. But unfortunately, these constitutional framers have their own political ideologies. For political gains, the constitutional framers themselves deviated the constitution, destroyed the constitution. Rather, this is the most unfortunate thing. Having struggled for 150 years for freedom, having sacrificed lakhs of people, and having spent 2 years, 11 months, 18 days in drafting a constitution, ultimately the constitution is just disregarded. I have no hesitation in blaming every politician of those days, whoever were the constitutional framers, including Dr. Ambedkar, Jawaharlal Nehru, the communists, the socialists, the Hindu Mahasabha. Every politician in the country since 1947 are responsible for distortion of the constitution. We are suffering the results. Main brunt of this disorder is being borne by the citizens of India today. We are suffering poverty. We are suffering hatred among caste, communities, creed, religion, languages. There is utter poverty. The law and order situation is appalling. In one word, intelligent people, whoever are capable, are preferring to leave this country. This is a shameful situation. Indians are loving America. They want to live there. They don't want to live in India. What is this? These political leaders with political reasons, they have destroyed the constitution. They have divided the people into caste, community, creed, religion, language and sex. They have incited violence among them, and they implanted hatred among themselves for a vote bank politics. The governor of a state is appointed by warrant under hand and seal of the President of India, and the term of office of the governors shall be during the pleasure of the President. Because it is after all he who should rule this country as a unitary, because he being the only elected executive in India. If a governor does not function according to the needs of the people or if he violates the constitution, or if he misbehaves, if he is incompetent. In all such circumstances, a president must be free to remove a governor and appoint a new one, more efficient one in his place. Otherwise, the country cannot be run. If different political parties rule these states, they fight among themselves, they fight with the center. We have seen some of the chief ministers have advised the governors to dissolve their assemblies and go for elections. Such a heinous crime against the constitution is not contained in the constitution. Such nonsensical, meaningless, undemocratic, illegal provisions are there in the Pakistan constitution under Article 58 and 112. But such conditions as dismissing of legislatures and going for midterm elections are not contained under Indian constitution. Article 157 defines the qualification of a governor. He must be an Indian citizen and he must have completed 35 years of age, and he should not be member of any of the legislature, state or the central. If he is already one, he is deemed to have vacated the office. He must be 35 years of age and more. Please think for a while to act as secretary to the politicians. Is it necessary that he should be older than these MLAs? We know the age limit for contesting to the assemblies is 25, and age limit for becoming an MLC is 30, and a governor should be 35. Why? To act as your secretary, should he be elder to you? Should he be appointed by the President of India? To act as your secretary, have you chosen him? Have you appointed him? Have you elected him to do that purpose? He is, after all, the deputy of the President of India, and with certain extent of freedom to rule the state in accordance with the constitution and to seek instructions from the President under Article 160 in case there is any ambiguity. We will see the oath of office of a governor, which is contained under Article 159. He takes oath which reads as follows: I, so and so, do swear in the name of God that I will faithfully execute the office of the governor and to the best of my ability preserve, protect and defend the Constitution of India and the law, and devote myself for the service and well-being of the citizens of India. Please understand, such a lofty oath is not prescribed for anybody in India. The ministers or the judges, everybody has to take oath to be truly abide by the Constitution. It is only the President and the Governor who takes oath to preserve, protect and defend the Constitution of India and the law. And then the second part of their oath says that I devote myself for the service and well-being of the citizens of India. Is such a great oath of office is discharged by being a dumb secretary to the Council of Ministers? We are treating a governor to mean that he should not do anything except following the advices of the Council of Ministers. English is a foreign language to every Indian. There may be great poets who writes imaginations or who writes descriptions of things according to their imaginations. This is a different thing. As regards the constitutional English is concerned, everybody in India has failed to understand it. If you ask a child of a 10th class with an unbiased mind, he will definitely tell you the meaning of these constitutional words. They say that there shall be a council of ministers to aid and advise the governor. Aid and advise. Can advice ever become an order? And that too advices of subordinates to their superior, who has appointed them, who has power to remove them, who has power to allocate duties, delegate duties to them. Can you bind your superior by your advices? It is such a failure to understand the constitutional context, and the English language has destroyed India. It is time for the polity, press, judiciary and elite of this country to ponder over what is the scheme of the Constitution. The scheme of the Constitution cannot be to disintegrate the country. It cannot be to incite hatred and fight among people of different faiths, religions, etc. Freedom is not meant for conducting elections every day. Why everyday elections? Through midterm elections here and there throughout the country. Each state goes to elections on a different date. This is not necessary. The freedom is not achieved to conduct elections alone and distribute freebies and distribute notes to votes, deceive the people, declare that they have come to power, and then loot the resources of the state. This is not politics. This is not constitution. This is not democracy. This is not for which India gained freedom. Instead, it is a bondage. It is a open ground for everybody to grouse, to fight, to destroy. The governor of a state has power to pardon against crimes done by people in matters on which the state is empowered to make law. So he can nullify the punishments given by the judiciary. Whereas he cannot be summoned to courts, he cannot be arrested, no case can be brought against them. Why this sword and shield were provided to this executive, namely the president and the governors, to sit inside the Rashtrapati Bhavan and Raj Bhavans? Who will bring cases against them? Who will kick a dead dog? Indians have perfectly misunderstood, misinterpreted, misapplied the constitution to the disadvantage of the people and the country. Coming to Council of Ministers of a State, Article 163 says that there shall be Council of Ministers in a state with Chief Minister as head to aid and advise the governor in discharging his functions as governor. However, such aid and advice can be provided only in matters which do not require his own discretion, the discretion of the governor. Matters which require discretion of the governor, he has to function on his own. We have seen Article 53 says that he can exercise the duties of a governor by himself directly or through officers subordinate to him. So, certain functions which he has to do according to his discretion, the ministers are not empowered to advise. But unfortunately, in all matters, we are seeing governor is made a secretary, not a secretary, it is a dignified word. It is made a servant. It is still better. He is made a bonded labor. Without questioning, he has to follow whatever is said to him. It is most misfortunate. It is an insult to the constitution. It is an insult to Dr. Ambedkar. Supposing governor does a particular action. Article 163(2) says that it cannot be questioned whether the governor has acted on the advice of the ministers or according to his discretion. It is the final discretion of the governor to act in his own discretion or according to advice of the Council of Ministers. When he does something, it cannot be questioned how you did, whether based on the advice or you did it by yourself. An unquestionable authority. We have seen under Article 163, ministers are not entitled to provide advice to the governor in matters which require his own discretion. They are such a low-level subordinates before the governor. Coming to Article 164, which is related to appointment of ministers and their conditions of office. Article 164(1) says that the chief minister is appointed by the governor and the other ministers are appointed by the governor on the advice of the chief minister. And clause 2 says that their terms of office shall be during the pleasure of the governor. Because Council of Ministers is an advisory body to the governor. If he doesn't like the functioning of any or all of the ministers, he should be free to remove them and appoint somebody else who is up to his satisfaction. Instead, we are seeing some chief minister is becoming as of right with his majority in the assembly, and a government is removed through a no confidence motions. Unfortunately, this is an imitation of the Pakistan constitution. Removing chief minister through no confidence motion is contained in Pakistan constitution article 130 clause 5. And removing of the union government through no confidence motion is contained in article 95 of the Pakistan constitution. Such provisions are not there under Indian constitution. Indian constitution Article 75 and 164 say that ministers are appointed and removed at the pleasure of the president and governors. So somebody is occupying, is grabbing the assembly with majority, and he is appointing ministers and he is ruling the state and the center in the similar condition. But in fact, what should happen is that President of India is representative of a political party or a coalition of political parties. All the public representatives in India elect the President of India. He appoints governors. Through this set, he rules the country. It means that the President and his union ministers belong to one political party or one political coalition. And the state governor and the state ministers belong to one political party or one political association. So there would never be conflict between the ministers and the governor. If there is conflict, the result is that such ministers are removed by the governor and new one appointed in his place. That is the system provided under Indian Constitution. But the bills are passed by the majority parties in the assemblies, legislatures. It has to be assented by the executive. So a bill passed by the majority party is its own stand in a particular matter. Its assenting or withholding is the stand of another party which is in power through the president and governors. Ultimately, both the parties have to go to the people and say that we have passed a very good bill for the benefit of the country or the state, and the executive representing so and so political party has withheld the bill against the interest of the people. On the contrary, the other party which is represented by the president and the governors will also go to the people and explain that we have withheld the bill for certain reasons. The bill was intended to benefit the members of the majority party. They want to grab resources of the state through a law officially, which we cannot allow. So ultimately, it is the people who decide whether the majority party who passed the bill is right or the party represented by the president and governors is right in withholding the bill. This is the beauty of democracy. Without understanding this, like a land grabbing, people are grabbing assemblies and the parliament by purchasing votes, by inciting violence, corruption, notes to votes, whatnot, casteism, discrimination, etc. This is not politics. Indian leaders have not so far understood what is politics, what is democracy, what is constitution. Instead of playing on the problems of the people, they understood, they learned that the politics means accusing the other person of corruption or crime and promising of freebies to the people. Indian leaders understood politics only to this extent. Of course, politics anywhere is the game of acquiring power, retaining power. But unfortunately, in India, besides acquiring power, retaining power, it has become the source of looting the resources of the country because they need that money to face an unjust election. They have to pay notes to votes. They have to spend huge money in the elections. This is not proper democracy. This is not for which India attained independence. The ministers take oath. I told you, ministers, judges, everybody take oath to truly abide by the constitution, whereas the executive take oath to preserve, protect and defend the constitution. Each state will have an advocate general under Article 165 appointed by the governor and removed at his pleasure. And even his remuneration is fixed by the governor of that state. But unfortunately, the state council members under Article 171 and the posts of advocate general, all these positions are being filled by the majority party leader, whom we are calling a chief minister. These are the appointments which require the discretion of the governor, which in his opinion is capable of doing this. Or members of legislative council who are appointed under Article 171 clause 5 possess certain qualifications like being experts in arts, science, cooperative movement and public service. These are the discretion of the president which are unfortunately violated by the majority party in the legislatures in demanding that the governor should act as bonded labor to the majority party leader. Article 166 says that all the business of the state shall be executed in the name of the governor, and it is he who decides the rules according to which that should be done. And any order issued by him under his hand and seal cannot be questioned on the ground that it is not the one authenticated by the governor. And it is he who allocates ministries to his subordinates. Among the council of ministers, it is he who distributes different branches. Under Article 167, it shall be the duty of the chief minister. Please remember, it is the duty of the chief minister to report all administrative and legislative proposals to the governor. And then the governor has a right to ask for further details, and the chief minister is duty bound to provide further information as may be sought by the governor. You must have understood by this time that the president is a politician, he is the only elected executive in India. He appoints governors for the states, they appoint ministers, and the president rules the country through the governors and Union Council of Ministers. Thank you. Thank you for watching a video. I request you to please subscribe, share, and comment on my videos. I will be glad to reply to your worthy comments. I once again inform you that I have taken it as my life mission to disseminate this constitutional information among the citizens of India with fond hope that it would change the social, political, and economic order of this country for the good of this country. Thank you. Thank you for watching my video.